Customs Litigations. Global approach to fraud and illegal behavior at borders. Fraud, counterfeiting and smuggling. What is the definitions and distinction of legal regimes under contemporary customs law? Border crossings and the phenomena of fraud, to which they are subject, are legally governed by customs law. This customs law can be defined organically as the law contained in the Customs Code. It is therefore important for customs law to have a vocation which, despite the liberalization of trade linked to contemporary globalization, still considers the classic idea of economic protection at borders, considered as a specific sovereign function of protection in the fight against counterfeiting and trafficking, which is different from the simple collection of disparate taxes. Smuggling is in a way the star offense of the Customs Code, the most famous object of customs prosecution. The concepts of fraud and counterfeiting refer to concepts developed in other areas of law, criminal law and intellectual property law respectively. Customs law is therefore, in a way, the instrument for the repression of violations in other areas of law. However, it should be noted that, while the notion of counterfeiting is relatively precise, that of fraud is relatively broad. The legal concepts of fraud, counterfeiting and smuggling. 1. The notion of fraud. Fraud is the common name for violations of various laws and regulations that customs is responsible for enforcing. Rather, it draws a parallel with tax evasion. To define fraud, it is therefore necessary to refer to its etymological origin. Originating from the Latin word fraus, fraudus, action taken in bad faith with the aim of deceiving. Therefore, it is a deception or falsification punishable by law. In other words, fraud is an action that reveals to its perpetrator the willingness to circumvent certain legal requirements, whether they are spouse, co-contractor, co-partner, litigant, or harm others. It should be added that lawyers extend the notion of fraud by what they call fraud in the spirit of the law, which consists in applying the letter of the texts while trying to avoid their objective. Customs fraud is a violation of customs rules, but tax evasion is legal in that it consists of using the texts to avoid taxes. Specialists speak more euphemistically of tax optimization. As such, and except in special cases, evasion is not fraud, and requires special texts to be pursued, especially international evasion. It must also be clearly distinguished from a particular case of fraud that customs services may encounter, because it can be combined with a customs offense tax fraud. 2. The special case of tax fraud. Tax fraud is limited to certain aspects of these cases of non-compliance, irregularity, whether in tax or social security contributions, includes all cases where the taxpayer has not fulfilled his obligations, whether he has acted voluntarily or involuntarily, in good faith or in bad faith. This is in fact an act of non-compliance, as adopted by the OECD. Fraud involves an intentional act on the part of the taxpayer, determined to circumvent the law to evade the payment of the levy. Fraud is defined as deliberate criminal behavior. That being said, it should be noted that, point 1. The ordinary definition of tax fraud corresponds to cases of willful violation of tax law. This corresponds well to bad faith. 2. At the level of customs law, tax fraud occurs when the act of customs fraud, for example, the non-declaration of goods, is combined with a desire to evade tax or, otherwise, the transfer to a country of cash or precious metals and fraud, in order to conceal from the tax authorities taxable material, i.e., a portion of assets normally subject to wealth tax. Given the cross-border framework of fraud of interest to us, which logically refers to customs law, this will be international tax fraud. The two notions of customs fraud. While the notion of fraud is, in law, a generic one, smuggling and counterfeiting refer to specific characteristics. 1. Smuggling of contraband in customs law. Smuggling is defined as imports or exports made outside the offices, as well as any violation of legal or regulatory provisions relating to the holding and transport of goods within the customs territory. In particular, they constitute smuggling, a. imports or exports without a declaration, when goods passing through a customs office are removed from the customs service's visit by concealment in specially arranged caches or in cavities or empty spaces, which are not normally intended for the accommodation of goods. B. Fraudulent landings or fraudulent embarkations made either in port or on the coast. C. The removal or substitution during transport of goods dispatched under a suspensive procedure. The unjustified failure to observe the fixed routes and timetables, maneuvers intended to alter or render ineffective the means of sealing, security or identification, and, in general, any customs fraud relating to the transport of goods dispatched under a suspensive procedure. D. The violation of legislative or regulatory provisions, prohibiting export or re-export or making export or re-export conditional on the payment of duties or taxes or the completion of special formalities, where the fraud has been committed or attempted outside the office, and is not specifically punished by another provision of this code. Smuggling remains characterized by the transport of goods across borders and without respecting customs rules. However, while the basic definition of smuggling involves avoiding customs offices, it has been included in the definition of smuggling at these offices but with concealed goods. This is the case, for example, of a tampered vehicle containing prohibited goods, for example cannabis, in specially equipped hiding places. The legal concept of smuggling is therefore particularly broad, so that custom officials must know all the tricks of smugglers and illegal importers of goods, to hope they can be seized and punished. While smuggling is obviously the most visible central crime of customs law, it is not the only one. Customs offenses, which are relatively frequent in practice, are generally as severely punished as smuggling. Within customs offenses there is a distinction between campaign offenses, when the customs office is avoided, and office offenses, when goods are brought in, but without being correctly declared. Misleading statements are prosecuted as much as smuggling. 2. Counterfeiting. Customs are also responsible for punishing offenses in other legal areas. This is the case for intellectual property law. Customs authorities are also responsible for combating counterfeiting, because counterfeit goods are considered prohibited. All goods, whose import or export is prohibited in any way whatsoever, or subject to restrictions, quality or packaging rules or special formalities, shall be considered as prohibited. Counterfeiting, or counterfeit goods, is a particular offense, as it does not constitute a violation of customs rules, but constitutes an infringement of intellectual property law. Customs are concerned by this infringement, because the fight against counterfeiting requires close border surveillance, to prevent counterfeit goods from entering the national territory. Infringement is defined as the act by a person other than the owner of an intellectual property right or his licensee, to exploit this monopoly, thereby infringing the rights of its owner. It is an act that infringes the rights deriving from an intellectual property title, trademark, patent, copyright. Counterfeiting is also the term generally used to describe a counterfeit product. Trademarks and products that are the subject of counterfeiting are known as counterfeits. This counterfeiting is both a criminal offense and a civil offense, resulting in liability before civil courts to award damages. Its originality is that the criminal offense refers to the civil offense instead of being specific. Also, counterfeiting is punished by imprisonment and fine. Counterfeiting applies for any person who tries to sell, supply or rent goods presented under a counterfeit trademark, import, export, re-export or transship goods presented under an infringing trademark, industrially produced goods presented under an infringing trademark, give instructions or orders for the commission of the acts referred to above. where the offenses provided for in this article have been committed in an organized gang or on an online public communication network, or where the facts relate to goods dangerous to human or animal health or safety, the penalties of imprisonment and fines shall be increased. Sue. What are we risking? The applicable legal regimes. If judges declare that a particular action is an act of smuggling, this has consequences for the individual, who is the author of the action. Hence the importance of knowing the consequences of each specific customs offense. The customs regime is characterized by its severity, even if a transaction system, set up for the amicable settlement of customs disputes, can help to mitigate it. The practical problem with customs fraud is that it is generally a fugitive act, that can only be detected for a short time. Always remember, customs law is a criminal law that derogates from ordinary criminal law. Indeed, this fraud does not lead to the disapproval of public opinion, such as theft or fraud, since the originality of customs offenses explains and justifies the severity of customs law, the survival of the repressive system of past centuries where, in particular, the personality of the perpetrator of the illegal act was not taken into account. Because of their instantaneous nature and the difficulty encountered by the customs in proving those of which it is only aware a posteriori. What is the relationship between customs law and other duties? If customs law is a global law, it is a right of superposition. On the basis of its border jurisdiction, it attracts several legal fields beyond the transport of goods, e.g. counterfeits. But within itself, it brings together dimensions that are usually distinct: criminal procedures, certainly, but also civil, fiscal, administrative procedures. The articulation of procedures and the possibility of cumulative penalties make customs law a very original and formidable criminal law. In view of the difficulties involved in detecting customs fraud, customs law provides the administration and the judge, who retains his discretion with a very specific arsenal characterized by the legislator's desire, to be able to bring cases to the attention of fraudsters on a very wide scale. To this end, customs law imposes a genuine presumption of liability on those responsible for an offense, which therefore entails the obligation on the respondent to prove his good faith. Moreover, the notion of complicity under ordinary law applies, but with an extension to all those who are interested in fraud, that is, those who contributed to the offense, but also, and this is very original in relation to ordinary law, those who covered fraudulent acts a posteriori. This extension is achieved by the introduction into customs law of the specific concept of interest in fraud. Consequently, complicity, which in ordinary criminal law can only be prior to the commission of the offense, becomes in later customs law, with all the consequences attached to it, in particular solidarity between convicted persons. This aspect is considered very important. The very content of the sanctions, the possibility of cumulation, reflects the particularism of customs law. Fines, of course, but above all prison sentences reflect the traditional repression pursued by customs criminal law. In the case of smuggling, there is a gradation. Thus, the traffic in counterfeit goods is punishable by a firm period of imprisonment and the payment of a fine between 1 or more times the value of the object of fraud. But these usual sanctions, heavy, as we have just seen, are not all. They are accompanied by sanctions whose practical interest is obvious. Consequently, confiscation of the object of fraud, confiscation of means of transport, confiscation of objects used to conceal fraud, confiscation of property and assets, which are the direct or indirect proceeds of the offense, especially when these offenses relate to goods of the category of those which are prohibited or heavily taxed within the meaning of this code. This confiscation may be ordered by the judge at the request of the administration. Except in the case of prohibited goods, the property is then returned once the related taxes have been paid. What are the articulation of customs and other procedures? The contentious customs procedure under ordinary law is the responsibility of the civil judges. This concerns cases where an individual wants to dispute the amount of customs duties that the administration is charging him. However, in the event of a customs offense, the criminal court has jurisdiction. In addition to the most prominent customs offenses of smuggling, which are not exactly criminal in nature, there are also foreign exchange offenses, tax offenses, border value-added tax offenses, and others are borrowed, such as the offense of corruption, and finally administrative offenses, for example, failure to declare within the time limit, or inaccurate declarations. This leads to several possibilities for action: criminal proceedings, before the criminal judge to punish; customs proceedings, before the same criminal judge to specifically punish the violation of customs law. For example, if a smuggler crosses the border into a stock of counterfeit goods without declaring them, he may be prosecuted for trafficking in counterfeit goods, and sentenced to the fines provided for. In addition, he can still be sued before the civil court for compensation for damages caused to the owner of the rights that have been infringed. But he can also be prosecuted under customs law before the same criminal judge, the criminal court, to impose customs tax sanctions in addition to the criminal sanctions mentioned above: a fine of between 1 and 2 times the value of the object of the fraud, confiscation of fraud goods mandatory for judges in counterfeit cases, means of transport, and objects used to hide the fraud. Finally, the same judge must, in addition to the tax penalties, order the payment of the fraudulent sums, that is, the customs duties, that the smuggler should have paid at the time of customs clearance. In tax law, as in customs law, the accumulation of penalties is a principle that applies. This is justified by the mixed, repressive and compensatory nature of customs fines. Admittedly, it is still necessary that accumulation be physically possible. Thus, customs may confiscate the same object only once. The fine may be added to a confiscation of sums of money. The standard classification of customs offenses and contraventions. First-class contravention: any infringement of the laws and regulations that the customs authorities are responsible for applying, where such irregularity is not more severely punished by the Customs Code. 1. Omission of an indication on customs declarations, without affecting taxation or prohibitions. 2. False declaration of species, value or origin, without affecting taxation or prohibitions. Second-class contravention: offenses the purpose or result of which is to evade or compromise the recovery of a duty or tax, provided that they are not more severely punished by the Customs Code. 1. Deficiencies in the number of packages reported. 2. Deficits on the quantity of goods placed under a duty or tax suspension procedure. 3. Total or partial non-fulfillment of the commitments entered into in the surety receipts and bids. Third-class contravention: offenses specifically listed in a restrictive list provided for by the Customs Codes. Smuggling, importing or exporting without a declaration of goods that are neither prohibited nor heavily taxed. Any misrepresentation in the designation of the actual consignee or consignor. Fourth-class contravention: offenses of a special nature. Point 1. Refusal to disclose documents or conceal documents or transactions. Point 2. Offenses related to the withdrawal of approval or authorization to clear customs. First-class customs offense: smuggling, importing or exporting without a declaration of prohibited or highly taxed goods. 1. False declarations in the case in point: the value or origin of the goods committed by means of invoices, certificates or any other false, inaccurate, incomplete or not applicable documents. 2. False statements or misrepresentations with the purpose or effect of obtaining any advantage attached to the import or export. 3. Lack of proof of origin for goods subject to proof throughout the customs territory: narcotics, alcohol, tobacco, jewelry, medicines for human use, etc. 4. Fraudulent acts with the purpose or effect of obtaining any advantage for goods traded within the customs territory. Second-class customs offense. Money laundering, export, import, transfer or compensation in the context of financial transactions abroad involving funds derived from breaches of the customs code or drug legislation. 1. Laundering concerning funds derived from breaches of legislation on substances or poisonous plants classified as narcotic drugs. 2. Money laundering concerning funds derived from breaches of the customs code, smuggling of alcohol or cigarettes, agricultural fraud affecting the community budget, etc. Third-class customs offense. Opposition to customs control. The fact that the occupant of the premises obstructs access to, reading or seizure of documents or documents in computerized form, when this obstruction is noted in the premises occupied by the person likely to have committed the customs offenses. Thank you for your attention, and I hope you enjoyed this course. For practical questions, please feel free to contact me directly by email. Cordially.